203-9556.
That is correct.
Thank you so
For
much.
joining me this morning. Please give me a thumbs up so I know that my audio is coming through clearly for everyone. Looking good. Okay, fantastic. Before we begin with the docket and the cases today, I have a few announcements I am going to make just for everyone. This is some good information to be aware of. The first thing I'll just remind all parties, and most especially reminding landlords, is that the Federal CARES Act is still in application here for Travis County. So if you're pursuing a case based on non-payment, if the eviction is based on non-payment, we will be asking if the property is covered with a mortgage under the Federal CARES Act, and if so, a 30-day notice of proposed eviction is required as opposed to state law of 3 or that which you may have in contract between the parties. Another thing to be aware of, and this is very important, especially because the holidays are upon us, is that for all parties in an eviction case, if there's a final judgment made, whether you win or lose, you have, per state law, 5 days to appeal. However, and here's the important part, the 5th day, if day 5, and it starts counting tomorrow, if the 5th day falls on a weekend, a holiday, or a day that our lobby is not open or closes early, you get until the next business day to perfect an appeal. So please be advised that our lobby will be closed all next week because of the holidays and staffing issues, okay? Which means that for landlords and tenants both, the eviction deadline or the appeal deadline is going to be extended substantially more than you would otherwise need to calculate. I'm not allowed to tell you exactly what day it ends. That's considered legal advice. Instead, I have to tell you that is the rule. And therefore, if you need help exactly understanding that deadline, please contact a legal aid. And then with that, I'm going to share with you 4 resources. And these are not the only 4. These are just 4 that I can recommend highly for free advice, and they can assist with both landlords and tenants and occupants. So really for everyone, these are some great resources. I'm going to share my screen. I'm going to highlight the websites, and my clerk is already putting those into the chat box for the parties. You can also find this information on our website, but just to give you some sense of what's available to you out there, and you can do this via phone, via email, in person, a lot of these are options, and they have them in multiple languages. Travis County Law Library are going to be closed for in-person visits next week as well, but they are available via phone and email. And this website can be translated in the upper left-hand corner into Spanish, so it makes it very easy to understand. But if you visit this website, when you scroll on down, you'll see that here on the right-hand side, there's an entire section for evictions, including how to appeal for tenants and for landlords. So again, resources available for all parties to an eviction case, including how to file them, and then some programs that may be available. Another great resource is the Austin Tenants Council. The Tenants Council is a project from the Texas Rio Grande Legal Aid Nonprofit Forum. The Tenants Council is definitely more to assist tenants and occupants, so landlords probably not going to be able to give you any telephonic counseling, but their resources and their education on their website may be helpful to all parties to understand rights, responsibilities, deadlines, what needs to be proven up in a case, and what can happen on appeal. TexasLawHelp.org is a website that is sponsored by the State Bar of Texas. It is available for all parties in the state of Texas to visit, and it is also available to be translated. You can click in the upper right-hand corner to translate this into other languages, and they have lots of information about, for both parties, and an eviction in all landlord-tenant situations, what to do in certain areas, and how to proceed with those cases. The last resource I'll give you is a really good resource because it applies for all justice courts in the state of Texas. And this is a justice court. All evictions must begin and start in justice courts. This is called the Texas Justice Court Training Center. It's actually the resource for judges like myself to go to and be taught how to do evictions. They have a website available for self-represented parties, landlords, tenants, occupants, everyone. And they have wonderful resources and very, very specific step-by-step books about what to do if you're in an eviction, if you're appealing an eviction, what to do if you need repairs, all other things, and they have those available in Spanish. This is good resource if you find yourself in another county in Texas. This training center teaches judges across all 254 counties. So a good resource to have. It can be very helpful if you're going to know, I wonder how another judge might view it. This is the guidance that all justices of the peace are given, and we are encouraged to share this with self-represented parties. So again, these are just 4 examples of free resources that you can email, you can find online to help you understand exactly what to do and when to do it by. Okay. With that,
Sorry.
yeah,
I was gonna say before we get started, I did want to make another announcement.
certainly.
So any appeals that are going to need to be filed next week, the week of Christmas, due to our office being closed, will have to be requested in writing prior to coming because they will be based off appointment only.
Yeah, but
So,
they can also, Brochet, because we close early, they get all the way until we reopen. If you want to
right.
file it next week, you can. That's a good point. Let's be very clear, though. If you want to come next week and file an appeal, you can, but call the office in advance because we can make special appointments. If you're not able to, though, you will get until we do reopen for normal, regular hours. I want y'all to be hearing me on this one. Very, very clear. The appeal deadline is extended, and therefore writ of possessions aren't going to be able to issue until we come to that deadline. You absolutely can come and visit us next week, but it's not like just show up because the building will be closed and dark and you'll go, hey, there's no one here. And I'm trying is very clear. We've got on our website, it's going to be on the doors to the building. There are other county offices in the building that may be open, but our office is going to be remote next week. So if you do need to come in person to hand deliver something, to bring a check for rent or something, please call or write us in advance. We can make some availability for that, but it's going to be by appointment only and sparing, okay? Otherwise, we will reopen for normal hours after the 1st. Thank you, Brochet. I'm glad you want to highlight that. That's very, very important for parties. So we want to do our best, but we also don't want to give anyone a misimpression that, you're missing something. Okay. With that, we are going to ask if parties would raise their right hand. I'm going to swear everyone in group. Please understand that by appearing before me today, when you present your case or your defense, you are sworn to tell the truth, the whole truth, and nothing but the truth under penalty of perjury. Do you understand that?
I understand.
Okay, fantastic. All right.
Yeah.
Brochet, did we have any parties when they checked in that were already resolved or said they don't need to proceed, or all 8 cases going?
All of our cases are moving forward, Your Honor.
All right. And which cases did we have both parties appear in? Do you want to?
Yes, ma'am.
First.
We can start with 1197.
Okay. First case will be 23-1197. That's Mila Wedemeyer versus Cynthia Chan. Do I have someone here on behalf of the plaintiff, Wedemeyer?
That's me.
All right. And are you owner, agent?
I'm agent, authorized agent.
All right. And how about someone here for Cynthia Chan?
That's me. Can you hear me, ma'am?
Yes, I can. Good morning. Thank you for being with us. All right, let me open.
Good morning. How are you? Quick question. She says she's agent, but she's actually tenant. She's one of the roommates, so I don't understand.
All right. Well, we'll ask her some information here, so I'll get to that. That's important. All right, Ms. Wedemeyer, what's the reason you're pursuing an eviction against the defendant?
She has been aggressive and belligerent towards me and the person that she knows, to my other roommate, to let her in the house. And I'm here on behalf of Sienna Properties to try and to evict her because we are moving out of the house. We have been trying to move out of the house because of her behavior. She also said that she was going to pay us rent. And we haven't gotten any of that either.
Okay, you said a whole bunch of things in that. Let me clear some things up. Do you personally, in your name, have a lease with the defendant?
No.
Is there a lease with you and the defendant on it and someone else?
Not a written lease, no. We have an oral lease.
Who is the oral lease with?
That's with okay.
Miss Chan, please don't interrupt.
Sorry.
Plaintiff has to prove their case up, or you can just be silent and you might win that way. For all defendants, you are best to serve to just remain silent until I ask you. You will always get a chance to respond, but the plaintiff in every lawsuit, no matter what, bears a burden of proof. They have to show me it's likely than not. Otherwise, they're not going to get anywhere, okay?
I just wanted to inform you that I have to inform APD that she showed up for court. I still have to go talk to them.
Okay.
They're both going to be being arrested. They robbed me.
But I need to hear from the plaintiff how they have standing to be in court, okay? All right, so Ms. Wedemeyer,
Yes, ma'am, I understand.
you said that you're on a lease with the defendant. Is that correct?
An oral lease, yes, ma'am.
And who is the oral lease with?
It's with me.
Do you own the property that she's leasing from you?
I do not own, I rent.
So what is she leasing from you?
A place to stay.
And where is this place to stay?
The garage of the home that I'm renting, of the duplex that I'm renting.
Got it. So you're renting a home and you're subletting the garage to the defendant.
Yes.
Okay. How did you come to have the defendant subletting the garage? Did you put an ad in the paper, on Craigslist, online, or did you already know her?
My roommate works with her, and the defendant asked my roommate if she could stay with us for a couple of days, and I said that was okay.
And then did y'all formalize that with an oral agreement about rent?
The formal agreement was you can stay here until you can find another place to stay. And then she started being aggressive towards us, and that changed.
Was there an agreement for the defendant to pay rent?
Not formally, but it was talked about.
And the answer is no, Ms. Wedemeyer. Are there any written rules for how parties must behave themselves in the unit?
Not on her lease.
Between you and the defendant. It's probably something you got. Do you have a written lease with the person who actually owns the home that you're renting?
Yes, ma'am.
Did you ever give a copy of that to the defendant?
No.
What specifically are you alleging the defendant has done that causes you to want to terminate her lease?
So I have text messages from October 17th, I believe. She started being very loud and bothering my roommate, and then in turn bothering me incessantly, almost harassing us, trying to get us to pay her because I don't really even know the full extent of why. She kind of talks in a lot of circles and it's hard to understand. But she is being aggressive towards my roommates and I, and harassing us.
When you say she's being aggressive, what do you mean?
She will get into our faces and yell at us. She will make a lot of noise. I don't want to say that she throws plates around, but it sounds a lot like she's moving dishes around, and there is a hole behind the bathroom door from her opening and slamming the doors. She also broke down the door to my bedroom to get in there.
Let's talk about that particular instance, Ms. Wedemeyer, because the other things don't. Ms. Chan, I'm going to give you one more warning. You would be best served to mute yourself because you're interrupting the dialogue, and I don't need it.
I didn't hear the last one to, what, a door was kicked into what room? Or
Ms. Chan,
what was that?
I'm going to follow up with questions. What I'm saying is you're talking and interrupting the conversation that I'm having, the testimony from the plaintiff, and that's not benefiting you.
Okay, I'm sorry. I was just trying to hear.
Especially since she's alleging that you're aggressive and loud. So being silent is the best thing you can do for yourself. And that's the last warning I'm going to give you, okay?
Okay, I'm sorry. I was trying to hear what was said. I'm sorry.
Listen with your ears. That's what my teacher used to always tell me.
I am. I have the phone actually up to my ear, but
okay.
I have a very bad phone.
Ms. Wedemeyer, the items you said about her getting in your face and slamming doors, those don't constitute actions sufficient to give rise to an eviction. But you said that she broke down your door into your bedroom.
Mm-hmm.
Let's talk specifically about that.
It wasn't
when did that happen?
Sorry. I'm so sorry. I want to say it was December 17 or 18. I've been making trips back and forth to the property, trying to get all of my stuff out so that I can leave. And whenever I came back, the door was broken.
Why do you have proof? Do you have proof that she did it?
I do not have proof that she exactly did it, no. But she is the only one that has a key to the house.
That's suspicious, but not conclusive, and certainly not more likely than not. It's likely.
Yes, ma'am.
Ms. Wedemeyer, did you give the defendant notice that you wish to cancel her lease with you?
Yes, I did.
Was that the notice of the proposed eviction, or was it a notice saying, I no longer want you to be a tenant with me, please move out after 30 days?
It was a notice to vacate saying I no longer want you to be here to live with us. It didn't have specifics on it. It had a note, it was a note card. It had dates, and I didn't know her real name at the time, so it said unknown tenant. It said that she needed to be out by the 27th of November. I gave that to her.
Ms. Wedemeyer,
I
let's,
have that.
Ms. Chan, I'm going to place you on mute.
Hello?
Yes, please stop talking.
Oh, I'm sorry. I was talking to myself, looking for a note card. I thought I was on
Ms.
mute.
Chan, I'm going to place you on mute. That way you can talk to yourself and it won't interrupt the proceedings, okay? When it's your turn, I will unmute you.
Okay.
All right, Ms. Wedemeyer, let's go through this very detailed. What day did you give this note card notice to vacate?
October 20th, or not October 20th. Let me look at my notes. I'm very, very sorry. No, it was October 20th of 2023.
And do you have a copy of the note you provided?
No, ma'am, I do not.
Do you recall exactly what it said?
It said notice of eviction, notice to vacate. It had October 20th on it, and it said, please be out by November 27th, 2023.
By November 27th?
Yes, ma'am.
What was the reason for that timeline?
I wanted to give her enough time to actually find a place to live.
Did you state a reason why you were telling her to move out by November 27th?
Not written, no.
November 27th is a Monday. Any particular reason you didn't give her until the end of the month?
It was because of whenever I gave her the note.
I'm not following, Ms. Wedemeyer. Why you gave it to her on the 20th? Why would you give her till the 27th and not till the end of the month?
I wanted her to have enough time to get out. I wasn't super focused on dates.
You didn't give her a full 30 days. So like you told her on October 20th, what you've got is a tenant sufferance. Even if she wasn't paying rent, you've got to give her, she lived there, she moved in. When did she move in?
September 12th.
And so a month and a half later, you said, listen, I want you to be out November 27th.
Yes.
But that's not actually 30 days, and it's not a 30-day month term. It's not till the end of the following month. It's just a day you chose.
Yes, ma'am.
Okay. And you didn't have a lease with her, and you didn't specify any particular reason you were asking her to move out. Just, we want you gone.
Yes.
Okay. All right. So after November 27th, did the defendant move out?
No, ma'am.
Did you give her a new notice then?
No, ma'am.
Did you just immediately proceed to filing the eviction?
I was trying to get my, I'll say no. No, ma'am.
You did file the eviction.
I did file the eviction, yes.
And you filed the eviction on December 6th.
Yes, ma'am.
And between November 27th and November 6th, did you give the defendant any notice that you were going to file this lawsuit?
She had notice before, but no, not in between that. No, ma'am.
No, I don't find that you gave her sufficient notice then. Okay. All right. All right, here's the thing, Ms. Wedemeyer. So you've got a tenant and you got to follow the law because you've become a landlord by subletting the garage apartment to her. And you can't rely on the lease you have with your landlord because it doesn't work that way. You have your own agreement with this person, right?
Yes, ma'am.
And you struck a very informal oral agreement that said she can stay until she finds a place to move. And there was no requirement that she pay rent in that. And you didn't give her any form of normal rules that she had to follow.
Yes, ma'am.
So the things you said that you were evicting her for is that she was loud and bothersome and began aggressive by getting in your face and yelling at you. And you could hear her in the apartment slamming doors and what you said you thought you sounded like throwing dishes.
Yes, ma'am.
None of those things under the lease you have give rise to the right to an eviction.
Yes,
You
ma'am.
absolutely have the right to terminate the lease with her. But in the situation you've got, you would have to give her a normal leasing period, which would generally be construed as a full month. And so that's why I asked you very clearly when you told her on the 20th, I want you to move out. To be proper, you would have had to give her to the end of the month of November, but you didn't. You gave her to the 27th, which is 3 days shy of a full month. Right?
Yes,
So
ma'am.
it's not 30 calendar days, it's the leasing ordinary month period.
Yes,
So
ma'am.
since you told her in October, you had to give her to the end of November. And at the end of November, when she was still there, even if you had done it right and given her till the end of November, you still would have had to give her an additional notice to vacate before you filed the eviction. And that didn't happen either.
Yes, ma'am.
Which means that today I would have to find in her favor because you didn't give her proper notice of the eviction.
Yes, ma'am.
All right. Now, you absolutely can appeal my decision, right? You can also start the process over if she's still in possession. Lots of things are available to you. I would encourage you and Ms. Chan to both look at some of the resources that we will provide and that we provided earlier and referenced to find out if you are still staying. It sounds like you're in the process of moving out, so this may all become moot. But if you want to do it again, you absolutely can. And then that's good information to have going forward. If you end up subleasing to someone again, you become a landlord and you are bound by the exact same formal property code rules as your landlord is.
Yes,
And
ma'am.
always there are two notices required. There's a notice of a violation or a notice of a lease termination. And then if the person